Senate Committee on Criminal Justice will come to order. Clerk will please call the roll.
Chair Flores,
Present.
Vice Chair Parker,
Here.
Senator Hinojosa,
Present.
Senator Huffman, Senator Miles, Senator King, Senator Hagenboom.
Present.
We have a quorum.
A quorum is established. Members, our agenda this morning focuses on improved tools to ensure that that our highways and streets are safe from Texans who drive while intoxicated, not just once or twice, but many times until they cause a traffic tragedy that causes the loss of life. Other legislation before us is aimed at improving our criminal justice system, target oil field thefts, and better protect the public and those who work in our juvenile justice system, and even improve the statistical transparency of our jails and inmates who are housed out of state. Our goal is to make Texas a better and safer place. It is the intent of the chair to lay out the bills one at a time, take invited and public testimony, and vote each bill out, so long as we have a quorum. That way we can move as efficiently as possible. If you intend to provide verbal testimony or would like to register a position on one of the more bills, please register at one of the kiosks located behind the committee hearing room. And testimony will be limited to invited testimony and public testimony will be limited to 2 minutes per witness, or as directed by the chair. So members, anyone have any statement or comments before we move forward? Okay. All right, we'll go to the first bill. Chair lays out Senate Bill 1320 and recognizes Senator Sparks to explain the bill.
Thank you, Mr. Chair and members. Good morning. Oilfield theft has become a multi-million-dollar criminal enterprise affecting businesses across the state of Texas. Cartels and other criminal organizations frequently target petroleum products, drilling equipment, and machinery, causing significant economic losses and safety risks. Law enforcement agencies are working diligently to combat oilfield theft, but face jurisdictional complexities, fragmented responses, and limited access to centralized data, which can make investigations and prosecutions more challenging. To address this, Senate Bill 1320 creates a dedicated unit within DPS with the authority to investigate and arrest individuals engaged in theft of petroleum products. While the unit has statewide jurisdiction, it will be headquartered in the Permian Basin, where oilfield theft is most prevalent. The unit will work in collaboration with local, state, and federal law enforcement, as well as the Railroad Commission, to ensure a coordinated approach to combating these crimes. The unit will provide specialized training to local law enforcement agencies, conduct public outreach initiatives, and maintain a centralized database to track oilfield theft incidents and related criminal enterprises. DPS will submit a biennial report to the Speaker, Lieutenant Governor, and legislators detailing the unit's activities, arrests, prosecutions, and asset recoveries, along with recommendations for improvements. And just in closing, I would say, the difference now from what we've seen previously is that it's easy for law enforcement to confirm now that this is all cartel activity, when it used to be kind of one-off, just petty theft things. And so not only are we looking to try and protect the oil and gas industry, but as we clamp down on the cartels, hopefully we reduce all crime. And so I ask y'all's earnest consideration for this bill.
So, Senator, just a quick question. So, in your opinion, and thank you for bringing this bill forward. So, I think I know the answer, but for the matter for the public is, why do you think that the cartels have zoned into the oil field theft, and created this big problem?
Well, for one thing, it's we're an easy target in that a lot of our operations are in remote areas, and your law enforcement in your counties, just don't have the manpower to really try and aggressively investigate all of these crimes. And so, and it's, you know, the oil and gas industry, as you guys know, it's a highly capital intensive industry. And so the cartels now have enough money. They're actually setting up, new companies to actually create more opportunities for theft. So it is a large scale operation.
Thank you, Senator. And any other questions, members? Senator Hinojosa?
Thank you, Mr. Chairman. You know, Senator Sparks, I support your bill, but the issue with oil, I guess, oil field theft and equipment, petroleum products, is not just at Permian Base. It's also happening along the border with fuel depots. It's become a very serious issue and problem. I give my question, and for us along the border, we try to coordinate with the Comptroller's Office and the different state agencies that have command or jurisdiction over this area. But how many, what's the personnel would be in this unit with DPS?
We have a few folks here for resources. I don't know exactly the personnel that they've designed this for, but I think I understand what you're asking about. Just because it's going to be headquartered in the out in the, you know, you got to headquartered somewhere. You know, Austin's not a very good spot, I would say. But out in the middle of the Permian Basin probably makes the most sense. But the expectation is it's going to coordinate efforts all across the state. And they're going to be, as you heard, they're going to be tasked for training local law enforcement, and that's going to be down in South Texas, East Texas as well.
And I think that we, Mr. Chairman, added some additional funding to be able to address this issue because it is a very serious issue. But thank you.
Yeah, thank you for your question.
If you show Senator Huffman is present. Thank you. So members, any more questions? Any questions? Senator Hagenbu?
Thank you, Mr. Chair. Just out of curiosity, what do you think the level of the monetary value annually might be for this?
You know, it's very difficult to ascertain, but when I visited with the DPS director a week before last, he told me that since border crossings are way down, I mean, they're at historic lows now since the Trump administration took over in January. He said oil field theft is now, the value of the theft is now exceeding the money that the cartels are making in peddling drugs.
Wow, yeah.
Yeah, it was shocking.
And if we don't stop, it'll probably only get bigger. So appreciate that. Thank you.
Thank you. No more questions. Thank you. We'll call, the chair now opens for invited testimony. Chair calls Floyd Goodwin, Bill Vanderland, Ammon Blair, and Michael Lozano. Well, since there are no invited, we'll go to public testimony. Invited testimony is closed. Public testimony now opens. So, same four witnesses. So we'll start on my right, and you have 2 minutes, and please proceed. Say your name, your position on the bill, and who you represent.
Good morning, Mr. Chairman, Mr. Vice Chairman, members of the committee. My name is Bill Vanderland, and I'm here today speaking on behalf of the Permian Basin Oilfield Crime Committee, and I'm speaking in favor of SB 1320. The Permian Basin Oilfield Crime Committee is a group of professionals from corporate security and law enforcement who have worked together for many years to combat crime in the oil field in the Permian Basin. And I began participating in that about 20 years ago as the supervisory agent for the FBI in the Midland Resident Agency. Continued that after my retirement from the FBI as Director of Corporate Security for Concho, when we were a very major player in the Permian before acquisition by Conoco. And now I continue that as a consultant. One of the previous questions mentioned trying to quantify this problem, and that is very difficult to do. Because the reported cases are only the tip of the iceberg. Many oil field personnel, they've reported things to their local sheriff's department before, didn't see anything happen, and so now they say, well, why bother taking the time? When it comes to oil, the theft of actual oil product is particularly problematic because without strong corporate gauging programs, particularly with older wells that aren't closely monitored, it's very easy for thieves to come and steal quantities of oil and it basically never be noticed. Yeah, there's a drop in production in this well, but it may be due to many factors. We'll just hot oil treat it and see what happens. Also, because of the pervasive hydraulic fracturing, during the flowback stage of a hydraulic fracturing, there are massive amounts of fluid, including oil produced, and frequently the companies end up having to shuttle oil back and forth between frac tanks and other tank batteries.
Thank you.
And informants tell us it's very easy to steal oil from that.
Thank you for your testimony.
Thank you, Senator and members. My name is Michael Lozano, and I represent the Permian Basin Petroleum Association in full support of Senate Bill 1320. To follow on Mr. Vanderland's comments, one of the most challenging things our industry has seen with regard to oil field theft as of late is this organized component that it far exceeds our ability as an industry to organize against, and frankly, this effectively means organized crime is meeting disorganized industry. And what we're trying to seeking to do with this Senate Bill 1320 is to allow DPS to help organize the law enforcement challenges that we see. Often these are not just crimes like Mr. Vanderland noted that are occurring in one location only. They are occurring across multiple jurisdictions, and that creates logistical challenges for our operators within the security confines that we create. With that said, our members have done great work on our own to establish best practices that we've worked with and established and provided to our members with the help of consultants like Mr. Vanderland and, of course, law enforcement across. So I don't want the committee to have the impression that we're not currently working with law enforcement or prosecutors or among the industry itself. Those things are occurring. But this bill, we hope to be part of a three-legged stool component. And the first is obviously having an organized law enforcement effort with this bill. We also have other bills that some of you may have heard in different committees related to the Railroad Commission's responsibility in that, as well as a bill that would enhance prosecutions also, or enhance penalties for those prosecutions to help really bring some of this under order. And going back to the challenge, I think we recognize that the Railroad Commission and industry, law enforcement, prosecutors all play a vital role in organizing against this new threat that is highly sophisticated, highly coordinated, and as Senator Sparks noted, is very lucrative for those bad actors. So we appreciate your support and your help in this effort in ensuring that this national security component continues to be vital because energy security is national security, and our members really support a coordinated effort to target these bad actors. So thank you.
Thank you for your testimony. Please proceed.
Good morning. My name's Floyd Goodwin. I'm the Chief of Criminal Investigations Division for Texas Department of Public Safety. I'm here neutral as a resource witness.
Any questions? Senator Hinojosa?
How many officers do you anticipate you may need to at least organize an anti-oil field theft unit?
Well, sir, currently we have two that are primarily working this, but we'll take as many as you want to give us.
Well, I think you're going to need more than two, quite frankly. It's not as small of a problem. It's a huge problem. It's happening while we have all our permanent bases really a epicenter, if you will, of oil theft. It's happening in other parts of the state, too, where they might need some expertise help.
Yes, sir, it is. As Senator Sparks said, it is really concentrated in the Permian Basin and in West Texas, which is our El Paso region, Region 4. We also see it in Region 3 down in the valley. That's our, and then probably Region 5. That's our three regions that really.
Pretty much a good chunk and part of the state.
Yes.
Thank you for answering my questions. Thank you, Mr. Chairman.
Please proceed.
All right. Good morning, Chairman Flores, Vice Chairman Parker, and honorable members of the committee. My name is Ammon Blair, and I'm a senior fellow at the Texas Public Policy Foundation. I am testifying in full support of Senate Bill 1320. I bring 22 years of military experience and extensive border security expertise from my service in the Army and the U.S. Border Patrol. This legislation is a timely and necessary step towards confronting an evolving and deeply rooted national security crisis, one that threatens not only the economic lifeblood of our state, but the very integrity of our territory, institutions, and sovereignty. Now, it must be clearly understood that while the proposed DPS unit is an important step, it alone will not be sufficient to defeat this threat. What we are witnessing requires a coordinated statewide and ultimately national task force approach rooted in intelligence, interagency integration, and operational readiness. The tools exist, they just must be employed with urgency. President Trump's executive order recently invoked the guarantee clause of Article 4, Section 4 of the U.S. Constitution. And also on January 23rd, the acting Secretary of Homeland Security issued a formal finding of mass influx of aliens and authorized direct cooperation between state and local agencies and federal immigration authorities. Most notably, the reactivation of the 287G task force model under the Immigration Nationality Act provides the deputization of state and local law enforcement to exercise full immigration authority with consent and training. The Organized Oil Theft Prevention Unit envisioned by 1320 must be integrated into the broader architecture. It must become the nucleus of a counterterrorism task force model focused specifically on the protection of Texas energy infrastructure. This means fusing real-time intelligence, field operations, legal authorities, prosecutorial tools, and community engagement into a single unified effort. It means deploying all of government capabilities, DPS, Sheriff's Office, and Texas State Guard, National Guard, immigration authorities, local prosecutors, private sector partners, and federal agencies to harden critical infrastructure and dismantle the adversary networks operating within our borders. For the security of our people, the integrity of our borders, and the protection of our economy, I ask for strong consideration of Senate Bill 1320.
Thank you for your testimony. Thank you all for being here today. Senator Parker.
Thank you, Mr. Chairman. Appreciate all of you being here and the excellent testimony. I understand what's happening, obviously, here with regard to cartel activity and so forth. I think it's a very important piece of legislation that Senator Sparks is bringing forward. I guess my question is, can you all speak to the sophistication? I want my colleagues to understand. I know Senator Sparks and I have talked about this and with others, the level of sophistication that's happening from these cartels. This is not just old school theft. It's much more advanced than that. And I just want you to, if you wouldn't mind, share with the members a little bit detail and give them some more background on that, if you wouldn't mind.
In order for particularly theft of product to pay, you've got to integrate it into the mainstream of the system. You have to do that by generating false reports saying it came from this well when in fact it didn't, came from this SWD, came from this reclaimer. And so it's very organized and requires higher level people that are setting up companies with a group of stripper wells that are now reporting production when it can't be happening, that are buying SWDs and using that to buy truckloads of stolen oil and launder it. The proximity to Mexico, you can go down to the export yards in Presidio, as I have done many times, and see quantities of oil field equipment stacked there waiting to go to Mexico that shouldn't be there.
Thank you for that, because I just don't think people realize that these are, frankly, folks that have left the industry or some kind of industry tie or knowledge or something to have that level of sophistication to do what they're doing. I mean, is that a fair assessment? No question.
Senator, I think that's absolutely correct. And I think one of the things our members have seen is the old joke used to be that things were stolen that weren't bolted down. Now we're seeing the bolts being stolen and sold also. And so I think the challenge our members are seeing is a really sophisticated effort. People that know how to drive these trucks, people that know how to enter leases, know the timing of where operations are occurring and when they're not occurring, when they can get on lease without having to be I guess, interdicted by our members' security forces on their own. Our members do have tight security on locations, especially in places where they're active, including saltwater disposal as well. But we've seen recent events where individuals in Reeves County were attempting to steal large quantities of crude in a saltwater disposal facility that exploded, and didn't just create some terrible damage and loss of obviously capital that investment made. They also created effectively an environmental disaster that burnt for several days. So the challenge for us is not just to mitigate the criminal element, but also the danger that exists for not just our members and their operators, but these thieves in general too. I mean, this is a highly sophisticated effort to know where to plug in on pipelines, where to plug in on tank facilities and batteries. I couldn't do it, so I can assure you it does take some sophistication.
Yeah, absolutely. And therefore, the unit that we're standing up is going to have some very specialized training and ability to understand uniquely what they're doing.
Absolutely,
right?
and I think our members will be heavily engaged in that best practice element for law enforcement, as well as them understanding what our members do and what we can help with them is understand too.
Excellent. Thank you all very much for being here.
Yes, sir.
Thank you. Thank you all for being here.
You bet.
Joe, Senator Miles, present. Thank you. Chair calls Philip McFurlow and Ed Longenecker. Thank you for being here. We'll start on my right. Your name, who you represent, your position on the bill, and you have 2 minutes.
My name is Philip McFurlow. I am the District Attorney for the 106th Judicial District
Welcome
in
back.
West Texas. We cover 4 counties, all rural, and there is significant oil and gas production in my jurisdiction, and we are in support of 1230. I'm now in my 3rd term. I have always prosecuted oil field crime. It has gotten significantly worse and significantly more complicated and complex over those 8 years. In the beginning, it was drug addicts stealing copper wire and just stuff laying around. Now it has turned into, I've prosecuted legitimate contractors that have created ties with organized crime and then gone and literally in broad daylight just go hook a tanker up to a tank, fill that tanker up, and then go put it in a different tank to sell it from a different company. Those cases are extremely difficult to make and extremely difficult to prosecute. Having a unit like this would be a huge boost to rural law enforcement. This falls on our rural sheriffs to investigate, try to coordinate with other rural law enforcement communities that are also patrolling and trying to keep the community safe. Having a DPS CID unit that's specially trained to work with oil field theft would be a huge bump. One of the worst cases I've seen in the last year, a group hit 3 pad locations one night. They stole pipe, they stole wire, they ripped out all of the existing wiring and the electrical components that were in the wells, creating well over $1 million worth of damage to those 3 pad locations. So again, this is a huge need. We thank Senator Sparks for bringing the bill, and we certainly thank you all for considering it.
Thank you. Thank you for being here.
Good morning, Chairman, Vice Chairman, committee members. Ed Longenecker, President of the Texas Independent Producers and Royalty Owners Association, or TIPRO for short, testifying in strong support of Senate Bill 1320. As Senator Sparks already articulated, while this is not a new issue per se, we have certainly seen an escalation in this type of criminal activity in recent years, and this is one of our top priorities for the 89th legislative session. We have held meetings with local law enforcement, the FBI, members of the Texas Congressional Delegation, the Texas Railroad Commission, numerous state policy leaders, and other stakeholders. And we also launched a survey recently to better track and quantify this type of criminal activity. Respondents to that survey, including large and small operators and landowners, not surprisingly, have reported the theft of crude oil, equipment, tools, materials, vehicles, everything associated with oil and gas exploration and production. One of the larger producer respondents reported $1.1 million in oil field theft and related damages between 2023 and 2024 alone, and that's just one example of hundreds, if not thousands, of companies in our industry that have been victims of this type of criminal activity in recent years. And that particular company utilizes all available security methods, including security cameras, operational hour changes, removal of load lines, heavy-duty locking mechanisms. They also employ former law enforcement with significant expertise and experience on this issue that are dedicated to that security function. As mentioned previously, you also saw the headlines about the explosion and fire in Reeves County, which was caused by a static charge in an attempt to steal petroleum from a facility designed for pipeline maintenance. And again, shocking that nobody was killed or seriously injured, and those criminals have yet to be apprehended. So this issue is not only a threat from a financial standpoint, but also a significant safety concern to workers, these companies, and communities. I'll stop there. This bill will have a meaningful impact on investigating, prosecuting this type of criminal activity. Thank you.
Thank you all for being here. Thank you for your testimony.
Thank you.
So we're showing no more public witnesses. Is there anyone present that wishes to testify on, for, or against Senate Bill 1320? Hearing none. Public testimony is closed. So Senator Parker moves that Senate Bill 1320 be reported favorably to the full Senate with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman. Aye. Senator Miles.
Aye.
Senator King. Senator Hagenbu.
Aye.
6 ayes, no nays.
There be 6 ayes and 0 nays. Senate Bill 1320 will be reported to the full Senate with a favorable recommendation. Senator Sparks, you wish this bill to be recommended to the local and uncontested? Senator Hinojosa recommends that Senate Bill 1320 be recommended for local and uncontested calendar. Is any objection? Hearing none, so referred. Thank you. Yes, sir. Yes, sir. Well, Senator. Yeah, but we can do Senator Perry here, who's here first, but yours is quick, you've got no witnesses. Chair lays out Senate Bill 826 and recognizes Senator Parker to explain the bill.
Thank you, Mr. Chairman. Members, appreciate the opportunity to come before you this morning and talk about Senate Bill 826. Driving while intoxicated poses significant danger to all road users, but the risk is even more severe in school zones where children, parents, and school staff are particularly vulnerable. School zones are meant to be safe areas where young students can walk, bike, and be dropped off or picked up without the heightened threat of impaired drivers. Despite existing DWI laws, enhanced penalties for offenses committed in school zones are necessary to deter reckless behavior and reinforce the importance of protecting children. Strengthening penalties for DWI in school zones would serve as both a preventative measure and a means of holding offenders accountable for endangering the most vulnerable members of our communities. SB 826 enhances a DWI that occurs in a school zone to a state jail felony. And with that, Mr. Chairman, conclude my remarks and appreciate the opportunity to come before you with the bill this morning.
Show Senator King is present. Are there any questions? Questions of Senator Parker? So as there are no invited witnesses on this bill, testimony is closed, and Chair now opens for public testimony. There are nobody registered. Is anybody here present to testify on, for, or against Senate Bill 826? Hearing none, public testimony is closed.
Thank you, Mr.
So Senator Hinojosa moves that Senate Bill 826 be reported favorably to the full Senate with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker,
Aye.
Senator Hinojosa,
Aye.
Senator Huffman,
Aye.
Senator Miles, Senator King, Senator Hagenbu.
Aye.
7 ayes, no nays.
There will be 7 ayes, 0 nays. Senate Bill 826 will be reported to the full Senate with a favorable recommendation. Senator Parker, you wish this bill to be recommended for local and uncontested?
Yes.
So Senator Hinojosa recommends that Senate Bill 826 be recommended for local and uncontested calendar. Are there any objections? Hearing none, so ordered. Chair lays out Senate Bill 1171. It will be a committee substitute will be following, Mr. Chairman? There is a committee substitute. Chair sends up committee substitute for Senate Bill 1171. Is there any objection to adopting the committee substitute for Senate Bill 1171? Hearing none, so ordered. Recognize Senator Perry. Explain the bill.
Thank you, Mr. Chairman and members. The Office of Inspector General of the Juvenile Justice Department investigate crimes committed by juveniles at department facilities. 1171 adds these OIG peace officers to Schedule C salary. It's continuing a trend. I think a good interim process would be to look at Schedule C and who all is in there and who all wants to be in there and figure out how to make that mix work. But this bill adds them to it until we get to that interim process.
Thank you. Any questions to Senator Perry? Hearing none. The chair will now call for. That's right. There is no invited testimony, so we will now open for public testimony, and the chair now calls Kevin Dubose as a resource witness. Kevin? Members, are there any questions for this witness? Any questions? Please state your name and who you represent.
Yes, sir. Good morning. Again, Kevin DeBose, Deputy Chief of the OIG, here on behalf of Chief Daniel Guajardo of the OIG.
Any questions? Thank you for being here.
Yes, sir.
So as we have no one else signed up for 1171 in public testimony, is anyone here who wishes to testify on, for, or against Senate Bill 1171? Hearing none, public testimony is closed. So Senator Huffman moves that Senate Bill 1171 do not pass, but that the committee substitute for Senate Bill 1171 be reported favorably to the full Senate with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa. Senator Huffman. Senator Miles. Senator King. Senator Hagenbu. 6 ayes, no nays.
There'll be 6 ayes and no nays. For committee substitute for Senate Bill 1171 will be reported to the full Senate with a favorable recommendation. Do you wish to go to local with this? Senator Hinojosa recommends that committee substitute for Senate Bill 1171 be recommended for local and uncontested calendars. Is there any objection? Hearing none, so ordered. We're now going to go to set. Let me go to this next one. Chair lays out Senate Bill 1727. There is a committee substitute.
Yes, sir.
Chair sends up committee substitute for Senate Bill 1727. Is there any objection to adopting the committee substitute for Senate Bill 27? Hearing
Mr.
none.
Chairman, it didn't actually get here. I'm going to go ahead and lay it out so that when it does get here, then y'all can,
When we'll leave the bill pending?
we'll leave it pending, subject to that.
we'll leave
It's just a ledge council draft is all it was, but it is not here today.
Okay. So is there any objection to adopting it?
You can't
We
adopt
we can't adopt what's not here,
I just
so.
want to make sure we're just going to.
We'll lay out your bill, and then we'll hear it.
Right, to change.
We'll put it pending, and then you come back and we'll change it.
Good, there you go.
So I recognize Senator Perry to explain the bill.
All right, thank you, Mr. Chairman and members. Data from the Texas Juvenile Justice Department indicates that juvenile assaults that are cause an injury to staff have continued to be a problem. 2020, there were 406 assaults. 2021, there was 382 assaults on staff. 2022, our inmates, our juvies. 2022, 422 assaults. 2023, 384 assaults. 2024, 476 assaults. Senate Bill 1727 is a continuation of a theme this session. We've had classroom violence. We have state-supported living center violence, employee violence, people on employees, and this is just another example how our state employees that we ask to go to work every day in these facilities are being assaulted by those folks that they have oversight over. Most of these assaults are from repeat offenders. That's important to know. Given any particular year, about 17% of the overall population at the TJJD facilities are the offenders. The department has 2 types of youth: youth on determinate sentences for a set number of years, and youth that are indeterminate sentences for an unknown number of years. Determinate sentences youth are eligible for transfer to the adult prison to serve the remainder of their sentence when they turn 19. In contrast, indeterminate sentenced youth are typically released entirely before they turn 19. TJJD often has more problems with indeterminate sentenced youth because their sentences do not come with the threat of being transferred to an adult facility. Senate Bill 1727 designates youth as having engaged in a habitual felony conduct and eligible for determinate sentence if the youth commits a new felony while in the TJJD facility. The bill allows the department to request that a court transfer a determinate sentence youth to the adult prison if the youth is at least 15 years of age and the judge determines the transfer is warranted. Currently, TJJD cannot make this transfer unless the youth is 16, so we're dropping the 16 to 15. Additionally, 1727 allows county probation departments to directly transfer a youth on a determinate sentence to TJCJ if the youth is at least 18 years of age, bypassing the state TJJD system entirely. The bill also prohibits TJJD from releasing a youth from a state facility if the juvenile has committed a pending criminal case. While at TJJD, they cannot be released. Senate Bill 1727 seeks to provide the department and law enforcement with necessary tools to address the violent assaults on staffs. Members, I want to be clear, I appreciate the efforts of TJJD has taken to address the assaults on their staff, but it is our responsibility to ensure that TJJD has the legal tools to maintain the facilities that are safe for both the youth that reside there and the staff that works there. So in a nutshell, we're asking to drop the age from 16 to 15 to send them. And I want to be clear, when we say adult jail, TDCJ has something referred to as Champions of Youth program. It typically houses less than 30 youth across the state, but it's kids that act like adults and offend in a very violent and aggressive way that would get this treatment. And it's causing, first of all, employee staffing problems, right? Nobody wants to go where they get beat up every day and no recourse to it. So I will say this bill has been filed in the past. Our previous colleague, Senator Whitmire, had filed this bill. It has been filed Republicans in the past, so this is a bipartisan conversation that's been ongoing for better part of several sessions. It's time to give the employees that sign up for these duties some level of assurance that they can go and work safely and go back home without offense.
Thank you.
I have a question.
Senator Huffman?
Thank you for bringing this bill, Senator Perry. It's really a necessary bill, and we've been looking for tools and trying to get this through for a long time, so good luck. I have a question, because you mentioned that if they're sent to TDCJ, you mentioned the Champions of Youth program. Do they have to go to that program? Because I know TDCJ also has age-appropriate, quote-unquote, age-appropriate facilities as well, where they have targeted younger people in the facility. So could they perhaps go to one of those facilities?
I'm familiar with the Champions of Youth, but there is resource witnesses available that you can
Okay.
ask those questions directly, because they may have a better
Yeah, I
answer
would
than
like to ask that question.
Absolutely.
There's someone there, because it would be nice to know what they're going to do with
Sure.
these kids. Do you have a,
Resource witnesses, you should have somebody from TJJD, and I
or
would
whenever you
assume
call them up, I'll ask, it's fine.
that may be a,
Or TDCJ. I
Well,
don't know if you have someone.
the chair will call up Chandra Carter, the executive director of TJJD,
so I
and
was
Sean
just handed,
Sean Grove.
Champions is for under 17, and I guess that's the
Okay.
only program that's
Okay,
available.
the under,
So,
yeah.
and these would be 15-year-olds in that facility,
Okay.
16-year-olds.
Okay, yeah, I guess I'm confused.
Good morning,
Clear
Shannon
that.
Carter, Executive Director, TJJD.
And Sean Grove, Deputy Executive Director, TJJD.
Senator
So
Huffman,
my
go ahead.
question, I was trying to figure out where these youth are going to go if they are, once they're transferred, and what's the age that could happen, and what type of facilities are available, and are they, and I'm asking because I'm curious, I want to make sure they're funded and available, and so I kind of like to know what the pipeline is going to look like.
I am not sure of the exact parameters for TDCJ. I know they have a youthful offender program that we have visited, and youth that have been determinate sentence offenders who've requested early transfer and the judge has granted have gone to that program. And it is a population of under 30. So those are the youth that I know of. I don't know if that is required or if there's alternatives.
There is a separate program for female offenders as well. And so the youthful offender program at the Ellis unit is for the male offenders. And the vast majority of youth, while the bill certainly does address the youth who we may request the court transfer earlier than 18 or 19 at the age of discharge, the vast majority of youth that TJJD does request a transfer for are those 18-year-olds. And so
Right.
they would go to the general population.
And then they go into the general population, but the population that TDCJ, I mean, to the facilities that house the younger offenders.
Yes, ma'am.
Generally.
Yes, ma'am.
Okay. All right. Thank you.
Any other questions? Any other questions, members? Thank you.
Sorry, members, we seem to live in a time when the kids today are a whole lot different than the kids than we grew up with. We live in a very angry society, but our employees shouldn't be the brunt of that anger. Thank you, guys.
Thank you.
Thank you. Thank you. So as there are no invited witnesses, the chair will now open it for public testimony. So the chair calls William Carter, Tina Lincoln, and Alicia Castillo. William Carter, Tina Lincoln, and Alicia Castillo. Good morning. If you please state your name, who you represent, your position on the bill, and you have 2 minutes.
Good morning, Chairman Flores and committee, and thank you so much for your time and consideration this morning on Senate Bill 1727. My name is Tina Lincoln, and I have served for Hill County Juvenile Probation Department for over 27 years. I proudly serve in Hill County, and I'm also part of the One Voice Committee for the state of Texas. I'm here in support of this bill, but I specifically want to speak to Section 4, Number 3, which states that after the child's 18th birthday, transfer to an appropriate district court, specifically pertaining to the determinate probation. For the state, this alternative allows for broader punishment range for certain offenses than was what permissible under the juvenile system, along with the possibility of transferring the juvenile post-adjudication to adult probation or prison if the juvenile does not avail themselves to the rehabilitative resources provided by the juvenile justice system. If a juvenile is placed on determinate probation, the current age of transfer is 19. During that time frame, most detention facilities will not take a 18-year-old and hold them in their facility, and services a lot of times for this particular age group are terminated. More importantly, there's not currently statute allowing for a juvenile to be detained either before or after the hearing to transfer supervision to the adult court. In essence, these youth that are pending transfer may not be held in a juvenile detention facility, which could be a potential concern for public safety. The court will still have the discretion not to transfer if the juvenile has met sufficiently the requirements set forth by the court. I really want to highlight that. The court still has the discretion to not do anything further when that juvenile turns 19 years old. However, if there is a violation of probation, they will have this opportunity and this ability to transfer. This is not a requirement, but it will provide the ability to transfer any time between the ages of 18 and 19, which will still be up to the local jurisdiction's court. This opportunity for transfer for determinate probation youth allows for continuation of services and accountability to address continued public safety. I thank you for your time this morning, and I'm happy to answer any questions that you may have.
Thank you. Thank you for your testimony.
Good morning, Mr. Chairman and committee. My name is William Carter. I'm the Chief Juvenile Probation Officer in Lubbock County. As well as Tina, I serve on the One Voice Committee. I've also worked in Fort Bend County and Harris County, so I've got a little variety of work experience. I want to say that this bill is really a victims' rights bill. You got to think about all the kids that we have in the state of Texas. 55,000 referred to us, go to 164 departments. A very small percentage of that goes to a juvenile detention center. There's 45 of those. We see violence, an ever-increasing violence in these young offenders from the past 4 or 5 years. When they assault my staff, that staff is a victim, whether it's a minor or a major offense. I've had a staff stabbed with a toothbrush that was made into a shank. We got to remember that all of the officers that supervise these juveniles, just like us, they walk and talk, they're doing a job, and they don't deserve to be assaulted. There needs to be repercussions when that happens. And Senator Perry's bill, I think, will address that and result in, I hope, a reduction in violence because they can see exactly what's going to take place. That's the end of my testimony.
Thank you. Any questions? I just have one question for you.
Yes, sir.
So you stated, and thank you for being here, if it's a long way to come, but yes, you stated that if within the last 4 or 5 years you've seen a dramatic increase or a large increase. Well, just at the top of your head, what would be like the top contributors to that?
Well, as far as overall offenses, gun violence is number one. There's been an increase in murders. I don't have the stats in front of me, but during COVID era, the juvenile murder rate shot up tremendously. Ag assaults, ag violence, and a lot of it is drug and gang involved.
Thank you.
Yes, sir.
Ma'am? Just Castillo.
Yes. Good morning. My name is Alicia Castillo. I'm Associate Director of Policy for the Texas Civil Rights Project, respectfully in opposition to SB 1727. I wanted to share, every victim to us matters, including the child victims in TJJD, both of their circumstances prior to entering the facilities and once they're in the facilities. So I want to name that the violence towards children in facilities has also increased recently in facilities from use of force, for example, in Evans in 2022 was 601 instances. In 2023, that shot up to 2,300 instances, and then 2024, 2,400 instances. That marketed increase is the same across all the facilities, but that's just for example. Same with chemical use of force, manual restraints, use of chemical agents. We shot up from 3 figures in 2022 in most of those areas to 4 figures. So that's violence against the children is also increasing, and I wanted to name that. But I also want to name that at both a time when both TJJD and TDCJ have been trapped in scandal for the past few years, but more recently have been called out for unconstitutional conditions. You all have seen, we've brought it to your offices, the DOJ report that highlights the instances of sexual abuse happening in TJJD facilities. The same thing happens in TDCJ. So something we say often is the only worse place than TJJD for kids is TDCJ. So I want to also name that this bill fundamentally contradicts the principles recognized by the U.S. Supreme Court in both Roper v. Simmons and Miller v. Alabama, which name that children have limited culpability compared to adults. They're limited in terms of maturity, decision-making, and susceptibility to peer pressure, but most importantly, their capacity for change is greater than that of adults, so an adult facility is just not an appropriate place for them. Additionally, federal mandates such as PREA are meant to keep children safe in adult facilities, but that results in sight and sound separation, which is solitary confinement for
Thank
kids.
you for your testimony. Thank you.
I'd be happy to answer any questions.
No questions? Thank you. Thank you for your testimony. As there's no one else registered for public testimony, is there anyone here who wishes to testify on, for, or against Senate Bill 1727? Hearing none, public testimony is closed, and we will leave this pending. Chair lays out Senate Bill 1080. There is a committee substitute. The chair sends up committee substitute for Senate Bill 1080. Is there any objection to adopting the committee substitute for Senate Bill 1080? Hearing none, so ordered. Recognize Senator West to explain the bill.
Thank you very much, Mr. Chairman and members. When an inmate is released from prison, the opportunities the inmate have taken advantage of while they're incarcerated directly correlates with the opportunities he or she will have outside of prison. According to the Prison Policy Initiative, using data from the National Former Prisoner Survey, nationwide, formerly incarcerated people are often relegated to the lowest rung of the educational ladder. In fact, more than half only hold a high school diploma or GED, and a quarter hold no credentials whatsoever, and we know that. Occupational licensing is a key to ensuring that former prisoners are able to have some of the best opportunities when leaving prison. Got to have transportation to be able to go from location to location. Inmates who are able to secure an occupational license while in prison increase their earning potential and reduce their likelihood of recidivism, and all of us know about recidivism. Senate Bill 1080's goal is to ensure that more people who are incarcerated have access to occupational licensing and to reduce recidivism. The committee substitute has been adopted as it relates to the committee substitute and this current bill. First, we want to address persons who receive felony convictions. The Senate bill makes a key change to licensing authorities. Licensing authorities are no longer required to revoke a license holder's license unless they're in prison for a felony conviction, a felony conviction for an offense that relates directly to the duties and responsibilities of the licensed occupation. Offenses listed in Article 42.054 of the Code of Criminal Procedure, which include very serious penal code offenses, including murder, capital murder, indecency with a child, sexual assault, etc. A sexually violent offense as defined in Article 62 of the Code of Criminal Procedure, and a felony community supervision, which is currently under the current law. And so the reality is this, that do we want to make certain that these persons are able to adjust when they leave prison? This particular bill applies flexibility to allow them to get their occupational license.
Thank you. Is there any questions for Senator West on Senate Bill 1080? I guess you laid it out pretty well, Senator. With that, the chair now opens for invited testimony, and the chair calls Deborah Gore and Emily McDonald. So we'll begin on my right, and if you state your name and you represent, and please proceed.
Mr. Chairman,
You
members
put
of
the mic close to you, please.
Mr. Chairman, members of the committee, my name is Emily McDonald, and I am in support of Senate Bill 1080. During my 13 years of incarceration, I was able to work in maintenance and earn occupational training in both HVACR and electrical. Although I was able to receive my EPA, my universal EPA certification prior to my release, I was unable to be licensed by the Texas Department of Licensing and Regulation, which is necessary to work in the field of HVACR. Once released, I started seeking employment immediately and was offered a job as a refrigeration technician within 2 weeks. Even though I submitted my application to TDLR within 10 days of my release, the process is tedious. I was required to obtain 3 reference letters from non-family members, a letter from my parole officer, as well as submit a detailed criminal history questionnaire. It took me nearly 3 months to receive notification from TDLR that I was registered as an air conditioning technician. Obtaining my license prior to release would allow me to walk out of prison and into not only a career, but financial stability. Senate Bill 1080 will make this possible for thousands of incarcerated men and women who currently have occupational training and intend to seek employment in their trade after release. Reducing the wait time between release and employment will reduce recidivism and give us a future that aligns with the goals of Wyndham School District and TDCJ.
Thank you. Any questions, members? Thank you for being here.
Mr. Chairman and members, my name is Deb Gore, and I am the founder of the Incarcerated Women's Project, and I'm testifying in support of Senate Bill 1080. I have had the privilege of teaching in various women's prisons for about a decade and currently teach a financial reentry class in the Patrick O'Daniel unit. The women often mention regret about past actions and their hope for a better future. This bill offers hope to women and men who want to step out of prison and improve their future and their families' futures. The current law prevents Texas inmates from getting a license until after release. They have to apply for, as Emily mentioned, and wait for their application to be approved, and the wait time is difficult when job need is critical and recidivism is more likely to occur. Released offenders have high potential, and we want them to be on their feet as soon as possible. Statistically, employment is the second greatest barrier that inmates face in successfully re-entering. Senate Bill 1080 makes employment more immediately accessible. There doesn't seem to be any reason for delay. Currently, time to employment after release is 18 to 20 weeks, with wages averaging $20,000 per year. Receiving licenses while still incarcerated will help Texas inmates to be able to step out the doors with more job opportunities and more earning potential. A number of great organizations are in support of this bill, including Texas 2036, the Texas Higher Education in Prison Consortium, Lioness, Unlocking Doors, Texas Appleseed, Texans for Free Enterprise, Ed Trust in Texas, Lone Star Justice Alliance, Cicero Action, and the Texas Business Leadership Council. We believe that this bill will increase jobs and earnings for those leaving prison, while also increasing the number of qualified license holders for future employers. Thank you.
Thank you, members. Any questions?
Mr. Chairman.
Senator West?
I don't have a question, but I want to make certain that the committee understands a couple of things. The bill changes the statute where licenses given to inmates are effective on the day of their release. And so when they get out on parole, they can get out there and get a job. And there's going to be an amendment on the floor, assuming the committee passes it out, to allow community colleges to also be a part of this.
Thank you, Senator West. Thank you for your testimony. There being no more invited witnesses, closed. Chair now opens for public testimony. Chair calls Christina Hartman, Kevin Sonic, Jessica Hurtado, and Jennifer Toon. We'll begin on my right. If you'll state your name, who you represent, your position on the bill, and you have 2 minutes.
Good morning. I'm Christina Hartman, Superintendent with the Wyndham School District, here on the bill as a resource.
Any questions for the resource? Thank you for being here.
My name is Kevin Sonic, Division Director of Instruction with Wyndham School District as a resource.
Any questions for the resource? Thank you for being here.
Good morning. Excuse me. My name is Jessica Hurtado. I'm a senior prosecutor at the Texas Department of Licensing and Regulation, here as a resource for you.
Any questions for the resource? None? This is quick. I like it.
Yeah, I'll keep it quick too.
That's okay. Please state your position.
Thank you. Thank you. My name is Jennifer Toon. I'm representing Lioness Justice Impacted Women's Alliance, and I am definitely in support of this bill. As a formerly incarcerated woman of about 20 years, and also as the executive director of Lioness, representing about 900 members of current and formerly incarcerated women, we support this bill because it offers a practical, powerful step towards improving reentry outcomes. Granting access to provincial occupational license immediately upon release gives people a real opportunity, not just a second chance in theory, but a concrete path to rebuild their lives. This is especially critical for women, many of whom are returning home to support families and communities already facing economic and social hardships. For us, this bill is about more than employment. It's about the ability to work with dignity, earn livable wages, and avoid unsafe situations just to survive. By removing the delay and uncertainty of licensure, this bill smooths the transition home from prison and helps ensure that our past does not outweigh our present readiness. It strengthens individual self-sufficiency, which supports healthier families and communities. We urge you to support this bill as it is a meaningful step in closing a serious gap in the reentry process. Thank you.
Thank you. Thank you for being here. Any questions, members? Thank you all for taking the time to be here.
Absolutely.
So I see no one else signed up for public testimony. Is anyone here wishing to testify on, for, or against Senate Bill 1080? Hearing none, public testimony is closed. So the chair moves that Senate Bill 1080 do not pass, but that committee substitute for Senate Bill 1080 be reported favorably to the full Senate with a recommendation that it do pass and be printed. The clerk will call the roll.
Chair Flores?
Aye.
Vice Chair Parker? Senator Hinojosa?
Aye.
Senator Huffman? Senator Miles?
Aye.
Senator King? Aye. Senator Hagenbu? Aye. 6 ayes, no nays.
There'll be 6 ayes and no nays. For committee substitute, Senate Bill 1080 will be reported to the full Senate with a favorable recommendation and will send it to the floor.
Yes.
Thank you.
476.
Chair lays out Senate Bill 476 and recognizes Senator Middleton to explain the bill.
Thank you, Mr. Chairman, members of the committee. Presenting Senate Bill 476 today. This is a bill that keeps Texans safe, but it's also personally impacted me and a lot of people in this room here today. In September 2022, 28-year-old Keith Brazier drove intoxicated through a red light at the intersection of Avenue O and 41st Street in Galveston, which is right in front of Ball High. And he collided with a Jeep and killed 14-year-old Mason Nelson and Samuel Mixon and badly injured Hannah Jackson. Keith Brazier had 3 DWI convictions in 2016 and 2018 and in 2021, and he had just been let out on parole for his 3rd drunk driving offense only hours before the fatal crash. Literally the first thing he did after he got out of jail was go drink, and he didn't even serve a fraction of his 3-year sentence. Brazier was under the court order to drive a vehicle with an ignition interlock device, but he figured out a way around that, and frankly, he made a mockery of that order. He simply drove someone else's car. He'd actually made videos about this previously, bragging about how to defeat an interlock device. There was something on social media where he got someone else to blow into a balloon and put it on the interlock, defeating that device. So he thought it was a joke. He was later convicted of 2 counts of murder and 1 count of intoxicated assault and is serving a 50-year sentence, but as we know, he's eligible for parole far sooner than that. This bill can help keep tragedies like this from happening again. It strengthens penalties for intoxication manslaughter when the offender violates a court order to use an ignition interlock device. Senate Bill 476 will send a clear message. If you disregard a court order and bypass an interlock safety technology device and someone dies as a result of your drunk driving, there will be serious consequences. Drunk driving already takes far too many lives in this state. But when somebody has already been restricted to driving with an interlock device, a safeguard that is intended to prevent tragedies, and they ignore that order, they circumvent the system, and they cause the death of another person, justice needs to be even more swift and more severe. Senate Bill 476 enhances the penalty for intoxication manslaughter to a first-degree felony, punishable by life imprisonment when the offender is under 18 and violated the ignition interlock restriction, and when the offender is over 18 and knowingly violates the same restriction by driving without the device, driving drunk without the device, it becomes a first-degree felony punishable by life without parole. This bill ensures that our justice system reflects the gravity of these offenses and provides a strong deterrent for those who would ignore the law and endanger others. We're not creating new criminal offenses or expanding the definition of intoxication manslaughter. We're narrowly targeting the most egregious cases when a driver knowingly bypasses a court-ordered safety measure and kills someone as a result. Senate Bill 476 is about accountability, it is about justice, it is about deterrence, it is about Mason, it is about Sam and Hannah and preventable tragedies, about making sure our law keeps pace with the tools and technology available to prevent tragedies like this. And I yield for questions.
Members, any questions? Any questions? Senator Hinojosa?
Thank you, Mr. Chairman. I guess I'm trying to understand your bill, and I know drunk driving is a huge issue, a big problem. We have tried to address that issue in many ways, and still there's some loopholes, if you will, in the statute. But your bill, what it does, if you have a person who gets charged with DWI one time, maybe a minor, right? And they have a breathalyzer device in their car, and they happen to mess with it and bypass it, and then they are out driving a second time, and they are under the influence, and they kill someone, what you're saying in your bill, it'll be a first-degree felony and subject to life imprisonment?
Right. Well, so right now it's a second-degree felony, and this elevates it to a first-degree felony only under the limited circumstance where you have not followed the court order or done something to defeat, the interlock device, and in the commission of that, someone dies because you're drunk driving.
And that's my point. So they would get life in prison.
Yes, if
bill.
Right, and not eligible for parole if you're over 18.
And it will be the same thing for someone that's an adult.
Yeah, under 18 is life. Yeah, over is not eligible for parole. That's the difference. Yeah.
So life will be 40 if you're under 18.
Right.
Okay, I understand the bill.
I have a question.
Senator Huffman?
And I'm following up with Senator Hinojosa again, just making sure I understand the bill. So there would have to have been an ignition interlock order, and then the prosecutor would have to prove that it had been tampered with. I'm trying to look for the language. Is that correct?
Tampered with or somehow defeated, or you're driving without it installed, drunk, and then you kill somebody.
Okay. And I understand where your bill, where it's coming from. I don't disagree, but I might just add something, and it's just a thought. Some judges, when I was a judge, like if I would not let people drive. So it would be you cannot drive. So there are judges that even do tougher things
Right,
than an So it seems to me if someone had been told not to drive and then they drove and killed someone, I don't know why they would be punished less than someone had been given the opportunity with an ignition interlock. So I'm
a
just
good point.
thinking maybe maybe a friendly amendment. I'm just
Yeah.
thinking where there had been a direct court order, because that does happen sometimes. I used to do it, and it was based on the situation. Sometimes you could just, depending on the individual, it was clear they shouldn't be driving, right? And sometimes we do that as judges. Judges do that.
Well, I like that amendment.
So just a thought.
Yeah.
Okay.
Thank you. Any other questions?
Well, I'll work with you on that
Thank you.
if you're amenable.
Thank you, Senator. We'll invite, since there is no invited testimony today, the chair will now proceed to public testimony. And the chair calls Jacob Manuel, Zach Davidson, Sally Bako, and Kirsten Budwine. So we'll begin on my right. If you'll state your name, who you represent, your position on the bill, and you have 2 minutes.
Good morning, Chairman Flores, Vice Chair Parker, and members of the Criminal Justice Committee. Thank you for the opportunity to testify today. Sergeant Jacob Manuel with the Galveston County Sheriff's Office. I'm here today to testify in favor of Senate Bill 476 on behalf of myself, Galveston County Sheriff Jimmy Fullen, and the entire Galveston County Sheriff's Office. I've been employed at the Sheriff's Office for the past 19 years, and during my tenure at the Sheriff's Office, had the opportunity to work as a traffic unit, enforcing state traffic laws, investigating crashes, and DWI enforcement. During my 6 years as a traffic unit, I accumulated more than 350 DWI arrests, and I have testified in all 4 district courts and the 3 county courts of Galveston County as an expert witness in DWI investigations and administering the SFSTs. November 7th, 2000. This is a date we should all remember. This is the start of the streak of death that is plaguing our roadways. Since this date, a person has died every day on Texas roadways. And according to TxDOT statistics in 2023, there were 26,080 impaired driving crashes that resulted in 1,138 deaths because of those impaired drivers. DWI is one of the most preventable crimes we have. With the technological advances we now have, driving impaired should not even be an option for anyone anymore. There are just too many choices for a safe ride home. 9 hours and 6 minutes. A person dies in this state due to an impaired driver every 9 hours and 6 minutes. Nearly 70% of the impaired drivers involved in those crashes in 2023 were repeat offenders, and more than 70% of those had BACs that were nearly twice the legal limit. In November of 2024, my oldest son was on his way home from work when an impaired driver crossed over a grassy median and struck my son's vehicle head-on. Only by the grace of God, a Good Samaritan witnessed the crash, stopped to help, and was able to pull my son from the vehicle as it was on fire. So I'm here today to support Senator Mays Middleton's Senate Bill 476 and the enhancements of DWI on offenders, not only from a professional standpoint, but also from the standpoint of a father whose son was a victim of a DWI crash that almost took his life.
Thank you for your service, and sorry that happened to you. And
Yes, sir.
And again, we really respect all your work that you've done. Please proceed.
Chairman Flores, members of the committee, my name is Zach Davidson, and I'm here testifying in favor of SB 476 on behalf of myself. Each year, thousands of families are impacted by drunk driving. We have tried raising awareness through PR campaigns. Everyone knows the dangers of intoxicated driving. We've tried providing resources to individuals struggling with alcoholism. Our courts use all the tools they can to rehabilitate those convicted of their first DWI. Technology has given rise to services like Uber and Lyft, providing safe and easy transportation alternatives. There's absolutely zero reason for drunk driving to continue occurring. Yet the stats show that none of this is working. Something needs to change. SB 476 sends a strong message. Texas will not tolerate repeat DUI offenders, specifically in cases where an individual bypasses court-ordered sobriety safeguards. In December 2023, my 9-year-old nephew was killed in a car wreck caused by a drunk driver. This topic hits close to home for me. Through my family's agony, a realization became just as painful. We are not the first family to have to endure this. We weren't even the only family that day that had to endure it. It is time that we as a state and a nation take all necessary measures to address the epidemic of drunk driving. SB 476 moves us in the right direction. No more families should have their worlds destroyed by drunk driving. I am proud to have Senator Mays Middleton as my state senator and extend my greatest thanks to him for filing this bill. Thank you.
Thank you.
Good morning, Chairman Flores, members of the committee. My name is Sally Bacco. I am the Director of Policy and Governmental Relations for the City of Galveston. I'm here on behalf of the City of Galveston to express our support for SB 476 and our appreciation to Senator Middleton. We support penalty enhancements to dissuade or prevent actions by repeat offenders that can result in what otherwise could have been avoidable tragic circumstances. Galveston has a population of slightly over 53,000 people, and we are blessed but face many challenges in hosting nearly 9 million tourists a year. For Galveston, our experience stems from tragic circumstances resulting from driving while intoxicated repeat offenders. Over a 4-week period on Galveston Island at the end of 2022 summer season, 3 separate drunk driving incidents resulted in the deaths of 6 people, including 2 teenagers and 2 children. This quite literally stunned the island. Senator Middleton has already described to you the tragic circumstances surrounding Mason, Sam, and Hannah. In one case, the man accused of killing 4 people in August 2022 was found operating a vehicle with an invalid license and without the court-ordered interlock device, which won't allow drivers to start a vehicle if they have a high alcohol content. In response to these tragic events, the Galveston Police Department formed a DWI task force, which has improved our effectiveness for arresting drunk drivers. But we need your help. The City of Galveston asked the committee to favorably report SB 476 as an important step to strengthen laws to meaningfully dissuade driving while intoxicated. Thank you for this time this morning.
Thank you for your testimony. Good morning.
Good morning. Dear Chairman and members of the committee, my name is Kirsten Budwine. I'm a policy attorney with the Texas Civil Rights Project in opposition to SB 476 today. I understand that this is a very sensitive topic, so I first want to acknowledge the tragedies related to driving while intoxicated that the author of this bill and the other crime victims have expressed today. No one should have to experience the everlasting pain of losing a loved one in this manner. That's why TCRP advocates for solutions that prevent this type of harm before it happens. According to the bill analysis, this bill is being introduced to deter those considering committing offenses while intoxicated. While we believe it is important to hold those who repeatedly commit intoxication offenses accountable, we don't believe that this bill will accomplish its intended goal or prevent tragedies like the ones that this bill is meant to address. Oftentimes, at the root of intoxicated-related offenses is a person with a substance use disorder. An estimated 65% of the U.S. prison population has an active substance use disorder. Mental health professionals have emphasized the importance of treating this disorder from a public health approach rather than a punitive one. Formerly and currently incarcerated individuals have expressed concerns with the inadequate and ineffective treatment programs available while incarcerated and the lack of continuity of treatment upon release. In fact, TDCJ's biennial rehabilitative program evaluations, which assess program outcomes by comparing recidivism rates of program participants, indicate that, quote, substance use disorder programs like PRSAP are so ineffective that participants are more likely to reoffend than non-participants. We ask that the legislature put more emphasis into preventative and rehabilitative solutions to this issue. Thank you.
Thank you, members. Any questions? Any questions? Thank you all for your testimony. Chair sees nobody else signed up for public testimony. Is anyone here wishing to testify on, for, or against Senate Bill 476? Hearing none, public testimony is closed. So the chair moves that Senate Bill.
May I?
Senator Hinojosa.
Yeah, I believe that we need tougher laws in the WI, and I don't necessarily disagree with the goals. It's just that I think this bill needs just a little bit more work in trying to pinpoint more or less those habitual offenders that are a real big problem. I'm just very concerned that you have someone that's a teenager and maybe having a drug problem, all of a sudden is sentenced to life. So this, I would hope that we just at least do it pending for us to look at it and work with Senator Middleton. I don't know how the committee feels. I'm just making a suggestion.
Members, any
Work with Senator Hinojosa, or I'm willing to vote yes. It's up to the chair.
would you possibly,
I'll be honest with you.
Senator Hinojosa, would it be amenable to that should we vote this bill out, that you look at some amendments on the floor?
I will vote present not voting then, and then work on it.
Yes, but some amendments on the floor, Worker Senator Middleton?
Yes.
So with that, the chair recommends that Senate Bill 476 be reported favorably to the full Senate with a recommendation that it do pass and be printed. The clerk will call the roll.
I don't know if I'll work.
But let's just stop.
Need to check to see how Boris is gonna vote.
Well, yeah.
Good read.
Yeah.
Yeah.
So, do you think we should hold it pending?
Yeah, we need to leave it pending.
We'll leave it pending. The chair reverses my motion, and we will leave Senate Bill 476 as pending. Thank you for your input. And with that, no, I'm gonna go there. Yes.
Okay, can we do first after?
Yes. Senator Miles? Chair lays out Senate Bill 2289 and recognizes Senator Miles to explain the bill.
Thank you, Mr. Chairman. Senate Bill 2289 requires that the county jail who contracts with an out-of-state jail report to the Texas Commission on Jail Standards how many inmates they may send out of the state and how many inmates may have died in those out-of-state prisons and facilities. We don't have enough officers in our jails in Texas, and some, especially in Harris County. This report will be a gauge on how well we are doing with staffing levels and how many inmates are being outsourced. The Texas Commission on Jail Standards requires one officer per every 48 inmates in county jails. When jails are not able to maintain this ratio, they must find solutions. 5 counties in the state have contracted with out-state facilities to meet this requirement, or from other overcrowding. And while Harris County does have the most out-of-state inmates, it is not just Harris County that has the problem. Unfortunately, since 2022, 3 deaths have occurred in facilities in Louisiana. We need to do what we can to increase the number of officers in our jails so that we can take care of our own population. But Harris County recently approved a $3 million to reduce overtime hours and hire new officers in county jails, which will help reduce the number of inmates being sent out of state. Senate Bill 2289 brings transparency and awareness to the problem caused by the need of more jail staff. We hope that this eventually, we will see no inmates on this report, but the Commissioner of Jail Standards is here as a resource witnesses. And I want to thank you for your consideration.
Thank you. Any questions? So the chair now opens invited testimony and calls Brandon Wood. Brandon Wood. Good morning. State your name and who you represent, and proceed, please.
Brandon Wood, Executive Director, Texas Commission on Jail Standards. Good morning, Mr. Chairman, members. I am here to serve as a resource, answer any questions that you may have regarding the reporting of Texas County inmates that are housed outside the state of Texas. The senator laid out the basic information. We do collect some of this data, but it is only a one-day snapshot, and it is not a running tally, which this bill would require. We also, by courtesy, if nothing else, the death in custodies that have occurred out of state have been reported to us, but we do not have purview to assign any investigation or require another state to conduct any investigation. And it would allow us to compile this information and provide it to the legislature to make any determinations what would be necessary in the future.
Members, any questions? Senator Huffman.
Yeah. So the responsibility, or who has the responsibility ultimately to provide the data to you? Is it that out-of-state, who you contract with? Or who they contract with?
It would be the county that would be required to submit the data to us.
Yeah.
And it would be a ongoing daily report, but it would only be compiled once a year.
So when they contract with out-of-state, however they do that, contract with someone to hold someone for them, and that would be part of the process that they would set up requiring this data, I'm assuming?
Yes, ma'am. The
Would
counties
this
that we
increase
currently.
the cost, do you think?
I do not believe that there would be additional cost regarding this. The counties that are currently housing out of state, they do keep track of the inmates that they have housed out daily, and they know the status of them, so I do
They're
not
just
believe that
not
it would be.
reporting it. Yeah.
They're not reporting it
Yeah.
except for once a month.
Okay. Okay, thank you.
Yes, ma'am.
Any other questions? Any other questions? Thank you. Thank you for being here. As I see no more invited witnesses, invited testimony is how closed. The chair now opens for public testimony. There's no one registered for public testimony. Is anyone wishing to testify on, for, or against Senate Bill 2289? Hearing none, public testimony is closed. Are we ready to vote on it?
Yeah.
So the chair moves that Senate Bill 2289 be reported favorably to the full Senate with a recommendation that do pass and be printed. Clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa.
Aye.
Senator Huffman.
Aye.
Senator Miles.
Aye.
Senator King.
Aye.
Senator Hagenbu. 5 ayes, no nays.
There be 5 ayes and no nays. Senate Bill 2289 will be reported to the full Senate with a favorable recommendation. Senator Miles, you wish to go to local?
Yes.
Senator Hinojosa recommends that Senate Bill 2289 be recommended for local non-contested calendar. Any objection? Hearing none, so ordered.
Thank you, members.
Senator Kokorst. Chair lays out Senate Bill 745. Recognizes Senator Kokorst to explain the bill.
Thank you, Mr. Chairman and members. Thank you for your hard work this morning. I'm going back and forth to B and C, and you've had a busy morning, and I appreciate the work that you do here, Mr. Chairman and members. Senate Bill 745 is a refile from last session of Senate Bill 726, which passed the Senate 31-0. It provides an additional sentencing option for prosecutors by creating a new first-degree felony offense for intoxication manslaughter for defendants who caused the death of more than one individual. This bill was based on a 2020 Washington County case involving 4 victims, including a 6-year-old and 2 18-year-olds. At the time of the collision that caused their deaths, the defendant was intoxicated and driving in excess of 90 miles an hour near Lake Somerville. The defendant pled to 20 years, which was the maximum punishment for all 4 victims, and avoided going to trial, which would have allowed the judge to stack the sentences. There have been cases in which multiple individuals have been killed by a drunk driver who received maximum sentence of 1 count of intoxication manslaughter. In these cases, victims' families have advocated for a change in the current sentencing structure for those charged with multiple counts of intoxication manslaughter. SB 745 seeks to address those concerns. Members, I had the district attorney from Washington County who was driving up this morning, and he actually had a wreck on 290 and totaled his truck very early this morning. So thank goodness he was not injured, no bodily injury. I saw a picture of his truck. So He's not with us today, but I do think that the District Attorney Association, County Attorneys Association was able to secure someone to testify if needed, Mr. Chairman.
Thank you, members. Do you have any questions? So as for invited testimony, we have Eric Carcerano. Eric Carcerano. Thank you for being here. Is there anyone, you have any questions? Please state your name and represent and proceed.
Good morning, Chair Flores and committee members. My name is Eric Carcerano. I'm an assistant district attorney in Chambers County. I'm testifying on behalf of myself in the Chambers County District Attorney's Office, and I'm testifying in favor of the bill. I want to first thank Senator Kolkhorst for again bringing this very important legislation. We worked hard on this bill last session and just couldn't get it across the finish line. As the law currently stands, the punishment range for a second-degree felony, which intoxication manslaughter is 2 years to 20 years. And by law, unless the judge decides to stack those cases, those sentences all run concurrently. So you could have a situation where there are multiple deaths, as the senator referred to, and you end up with one 20-year sentence. What this bill does is gives prosecutors another sentencing option to help take care of these cases. We're in favor of this bill, and I'll be happy to answer any questions.
Any questions? Senator Hinojosa? Senator Huffman?
Oh.
They were thinking about questions for you, but you did such a good job. We appreciate. Thank you for being here.
Thank you. Thank you, Senator. Thank you, committee members.
Seeing no other invited testimony, the invited testimony is now closed. The chair now opens up for public testimony. There is no one signed up to speak in public testimony. Public testimony is now closed. So, the chair moves that Senate Bill 745 be reported favorably to the full Senate with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman,
Aye.
Senator Miles,
Aye.
Senator King,
Aye.
Senator Hagenbill. 5 ayes, no nays.
There be 5 ayes and no nays. Senate Bill 745 will be reported to the full Senate with a favorable recommendation. Senator Corson was local. So Senator Hinojosa recommends Senate Bill 745 be recommended for local and uncontested calendar. Any objections? Hearing none, so ordered. Ready? Chair lays out Senate Bill 2320 and recognizes Senator King to explain the bill.
Thank you, Mr. Chairman, members. I became a police officer in 1977, and nothing has improved with regard to DWI injuries, fatalities since then. And I first came to the legislature in 1999. We had in Brock, Texas, which is just down the street from my house, we had 4 Brock High School girls killed in one DWI collision. And nothing has really changed in DWI fatalities since then. And today you're going to hear testimony from Lauren Muckleroy, a mom from Fort Worth whose husband and 2 young children were killed by a drunk driver on their way to see family for the Thanksgiving holiday in 2023. This bill is about protecting your children and grandchildren and loved ones. Frankly, I'm just kind of fed up at this point. Texas Department of Public Safety reports that over 13,000 driving while intoxicated crashes occurred just from 2022 to 2024, resulting in almost 1,287 fatalities. That means that 1 out of every 4 traffic fatalities investigated by the DPS during this time was the result of someone driving while intoxicated. The National Highway Traffic Safety Administration shows that over the 10 years from 2013 through 2022, there were approximately 110,000 100,000 fatalities in the United States involving an intoxicated driver. That is double the number of American soldiers who lost their lives during the Vietnam War. Let me say that again. We lost 58,220 soldiers in Vietnam, and just during the 10-year period, 13 to 22, twice that many were killed by intoxicated drivers. The consequences of driving while intoxicated endanger the lives of every person on the road, and too many Texans continue to become victims of this danger. SB 2320 takes steps to address this serious issue by just trying to increase the penalties for driving while intoxicated. The way the bill would work out, if passed, is first time driving while intoxicated offense, currently a Class B misdemeanor, would be bumped up to a Class A. Driving while intoxicated with an open container, which is currently a Class B, would be bumped up to a Class A. Driving while intoxicated with sobriety of analysis of 0.15 or more, which is currently a Class A, would be bumped up to a state jail felony. And driving while intoxicated with any prior DWIs, including in a boat or an aircraft or while operating an amusement park operation, would be bumped up to a state jail felony. It's really simple, but it's just trying, if nothing else, then let's make the penalties higher and see if we can't get people's attention. Someone testified earlier that today there's no reason with Uber and Lyft and the decades of public service announcements and all the advertisements and everything else we've done to try to curb DWI, and it still continues to take deaths every day in Texas. With that, I'd be happy to answer any questions.
Any questions, Senator King? With no questions for Senator King at this time, the chair now opens for invited testimony, and then chair calls Bill Rayburn and Lauren McElroy. Welcome. We start to my right.
Okay.
Ms. McElroy.
Good morning, Chairman, Committee, Senator King. Thank you for having me. My name is Lauren McElroy, and I'm here to testify in support of Senate Bill 2320. As Senator King mentioned, on November 22nd of 2023, my husband, Zach, my 12-year-old son, Judson, my 9-year-old daughter, Lindsay, and myself were driving from Fort Worth to Johnson City to spend Thanksgiving with my side of the family. Unfortunately, we never made it there because another vehicle, driven by a drunk driver, came across 281 and hit us head-on. I was seriously injured and care-flighted to Del Seaton here in Austin, but as Senator King mentioned, Zach, Judson, and Lindsay did not survive. Even as I speak those words out loud, it still doesn't seem real or possible, almost 18 months later. I don't remember much from that day, but I will never forget a state trooper telling me all 3 of them were gone. Because the other driver passed away, we didn't find out he was intoxicated until 3 months after our accident. Not only was he intoxicated, but he was found to have a blood alcohol content of 0.261, a little over 3 times the legal limit. In addition, the assumption based on the investigation is that he was drinking in his car while driving from his Marine base in Corpus Christi. This assumption was made based on the lack of stops that he made along the way and timelines determined from police interviews that were conducted. My entire family was gone in a senseless instant. But they weren't gone because of a freak accident or because we were just in the wrong place at the wrong time. I lost my entire family because of an irresponsible and selfish choice. This did not have to happen. My husband, Zach, was gregarious and kind, would do anything for anyone. His nickname in Fort Worth was Mayor Muck, not because he was ever officially elected, but because he made everyone who crossed paths with him feel important and special. Judson was silly, but also empathetic beyond his years. He loved video games, pickleball, football, and just being with his 6th grade friends. Lindsay was full of life. She was a Spitfire, and she would do anything to defend those she cared about most. She should be celebrating her 11th birthday tomorrow. But she doesn't get the chance to turn 11 or 16 or 21. She will never go to a prom. She will never get to go to UT, which was her dream starting in 3rd grade. This was all taken from her. Everything was taken from all 3 of them. They all had so much life left to live. This didn't have to happen. But this is what can happen when someone chooses to drink and drive. My hope and prayer is that lives can be saved as a result of our story, that others can have the chance to live their lives to their fullest as a result of what happened to us. If we can deter just one driver from getting behind the wheel and therefore saving just one life due to harsher DWI penalties, it will be worth it. Thank you for your time and consideration in supporting this bill.
Thank you for being here. I'm very, very sorry for your loss on behalf of us all, and it took great strength.
Thank you.
To tell your story, but hope you will make a difference.
Thank you.
Please proceed.
Mr. Chair, good morning.
Senator King.
Before we go to the sheriff, could I?
Please.
Thank you. First, thanks for coming down for this. I know how hard it is, and it stirs up things that really never go away.
Right.
And, you know, the story of what happened was really widely broadcast in the media, and I think everybody's heart fell, because that's everybody's greatest fear, is that you wake up from an accident and your family's gone. And there's not anybody in this room who hasn't thought about that occurring. And I just want you to know we love you, and we will fight for you and fight for this cause. And I just so appreciate you coming down and testifying. I know it's a hard story to tell, but thank you.
Thank you for letting me be here, and thank you for everything.
Thank you, Mr. Chairman.
Thank you, Senator. Sheriff.
Good morning, Mr. Chair and Senators. Thank you all for having me here. Madam, your courage is incredible. Thank you. Is DWI has, as I think Senator Phil laid out very well, that we have issues with DWI in Texas. In the last 2 years, law enforcement has arrested 170,000 people for DWI in Texas. It's about 235 people a day with loose missiles out there on our highways and byways. And I think from the previous bills that I have seen today, that this Senate is prepared to send a strong message that we're done with DWI. In Tarrant County, where I'm from, last year we filed 5,100 plus cases of DWI, but still yet we had 18 fatalities and over 30 crashes that had significant injuries just in our county. And that is duplicated all over the state. And to get the attention of the people of Texas and those that are coming in to visit, recognizing that we're a high tourist state, that we send a message, we're not tolerating this. We're not going to stand for this for not one more minute, and we can possibly see a reduction in DWI. I think law enforcement's doing as good a job as they can. We'd like to spur them to a little bit higher on trying to capture the DWI, but once we catch them, we want them to know that the consequences is significant. And what I've seen from this Senate, this committee so far today, they have agreed with that. And I would ask you to pass this bill, and let's stand shoulder to shoulder and say, well, we're not going to tolerate drinking and driving.
Thank you, Sheriff. Any members? Thank you all for being here. Again, our deepest condolences. So with that, there is no more invited testimony, so invited testimony is now closed. The chair now opens for public testimony. There is no one signed up to speak on public testimony. The public testimony is now closed. So are we ready to vote? Vote. Chair moves that Senate Bill 2320 be reported favorably to the full Senate with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa.
Aye.
Senator Huffman.
Aye.
Senator Miles.
Aye.
Senator King.
Aye.
Senator Hagenbu. 5 ayes, no nays.
There be 5 ayes and no nays. Senate Bill 2320 will be reported to the full Senate with a favorable recommendation. Senator King, do you wish this to go to local? Senator Miles recommends that Senate Bill 20. You don't want to go local? You want to go to the floor? Very well. Yes, sir. We'll tell the story on the floor. It'll be referred to the floor. Which one? 989. Chair lays out Senate Bill 989. Recognize Senator Betancourt to explain the bill.
Thank you, Mr. Chairman. This bill is a refile of Senate Bill 1973 from the 88th regular session. It was voted out unanimously and off the floor, but it didn't pass the House calendar in time. Concerns have been raised about individuals being employed by courts to determine bail and not going through criminal background checks prior to employment. Our largest county in the state is not doing background checks. This just simply requires that a special master, a master, magistrate, referee, or other court official who assesses or determines the eligibility or amount of bail from a criminal defendant goes through a criminal background check. The bill also establishes that criminal history record may be used to evaluate employment by an applicant and that any information obtained in the background check may not be released or disclosed. And lastly, SB 989 requires that after expiration of any probationary term of the person's appointment or employment, the court must destroy all criminal history record information. So it's a good background check bill, but also protects the rights of the employed. With that, members, happy to answer any questions.
Any questions, members? Any questions? So with that, there are no invited witnesses to testify. We'll move on to public testimony. Public testimony is now open. We see no one signed up to speak on. Is there anyone here who wishes to speak on, for, or against Senate Bill 989? Hearing none, public testimony is closed. So we do have a quorum, but will we be okay with this? We do have a quorum. We'll just vote it out. Everybody's okay? Yeah. So the chair moves that Senate Bill 989 be reported favorably to the full Senate with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa.
Aye.
Senator Huffman.
Aye.
Senator Miles. Senator King. Senator Hagenboom. 4 ayes, no nays.
Every 4 ayes, no nays. Senate Bill 989 will be reported to the full Senate with a favorable recommendation. Senator Bitcourt, you wish to go local? Senator Huffman recommends Senate Bill 989 be recommended for local, non-contested calendar. Any objection? Hearing none. So ordered.
1437.
Chair lays out Senate Bill 1437 and recognizes Senator Betancourt to explain the bill.
Thank you, Mr. Chairman and members. Safety concerns have been raised about the narrow scope of eligibility for the Juvenile Justice Department's Do Not Hire registry. Currently, the agency can only place certified officers on this registry. Those not eligible for the Do Not Hire registry include those employed by, in contract with, or volunteering for Juvenile Justice Department, a juvenile probationary department, or a juvenile facility registered with the department. The agency can't even place an individual on the registry if they are a probationary officer or engaged in misconduct with a juvenile. In the current system, unfortunately, sexual predators are able to move from one job to the next without employers being aware of their previous misconduct. This is a large gap that threatens the safety of those under our care in the state. So SB 1437 would close loopholes in the Juvenile Justice Department Do Not Hire registry. And with that, I'd be happy to answer any questions.
Members, questions? Questions? So with that, the chair now opens up for invited testimony. The chair calls Madeline Green. You'll state your name, who you represent, and please proceed.
morning, y'all. My name is Madeline Green, and I'm the legal researcher for the Texas Catholic Conference of Bishops. I'm testifying in support of Senate Bill 1437. Thank you, Senator Betancourt, for this important bill to close loopholes in the Juvenile Justice Department's Do Not Hire registry. The Catholic Church takes seriously our role in protecting children and putting an end to the evils of child abuse of any kind. That is why we take preventative and proactive measures to stop crimes against children before they happen. At last session, Senate Bill 1849 was implemented this summer and fall. We learned of some troubling gaps that in the Do Not Hire registry for Juvenile Justice Department. When we are hiring for our Catholic schools, we have access to this registry through an interagency search engine created by Senate Bill 1849 so that we do not inadvertently hire someone found to have engaged in inappropriate conduct with a juvenile. However, we learned that this registry does not include their non-certified positions, which leaves a gap in knowledge about probation officers who may have harmed children but are not certified, so it will not be picked up by the interagency search. Senate Bill 1437 closes that loophole and includes non-certified positions in the Juvenile Justice Department's Do Not Hire registry, which we can search through the interagency search engine. We all want to hire and retain employees and volunteers who have the best interests of our children as their highest priority. There is invaluable benefit to implementing collaborative and cooperative efforts so we can better screen out those who have the potential to cause them harm. Thank you, Senator, and for another important tool in preventing future abuse. Thank you.
Thank you.
Members, any questions?
No.
Senator
Thank you,
Betancourt?
Madeline. I appreciate your testimony.
Thank you for being here. As there are no more invited witnesses, invited testimony is now closed. Chair now opens up the floor for public testimony. Chair calls the following witnesses: Casey Singer, Laura Colangelo, and Chandra Carter. We'll start on my right. Start your name, who you represent, your position on the bill, and you have 2 minutes.
Casey Singer, Deputy General Counsel, Texas Juvenile Justice Department. I'm just here as a resource.
Thank you. Any questions?
Chandra Carter, Executive Director, Texas Juvenile Justice, here as a resource.
Questions, members?
Laura Colangelo. I'm the Executive Director of the Texas Private Schools Association. I am here representing the 941 private accredited nonprofit schools in the state, enrolling over 308,000 students. We are very much in favor of SB 1437, and we are grateful to Senator Betancourt for his ongoing work to protect Texas children from predatory behavior. I usually do not testify in this committee. It's a little unfamiliar here, or on any bill that does not directly and exclusively affect private schools. But improving each Do Not Hire registry and creating the interagency search engine is so important for all entities that serve vulnerable populations that we feel like we should speak up at every opportunity just to make sure that we close any loopholes that would allow predators to have access to juveniles in any context in the state. So once this interagency search engine is established, which I think is in a couple of years from now, then all of the disparate Do Not Hire lists will be accessible when private schools, public schools, any type of school conducts a search to make sure that the employee candidate is safe to be around children. This is a benefit to all child-serving entities for these lists to be complete and without exclusions. So this bill seeks to do that for the Juvenile Justice Department, but every agency will benefit from this improvement. So thank you.
Thank you. Thank you for being here. Senator Hinojosa?
Thank you, Mr. Chairman. But this bill doesn't apply to private schools.
No, it doesn't. But once these loopholes are closed for the juvenile justice system, when the interagency search engine is established, then that Do Not Hire list is combined with all the other Do Not Hire lists so that we can see who shouldn't be around children.
You're not required to do that.
We are required.
By law?
So private schools, yes, they have to report to the Do Not Hire list. Yes, but I'm trying to remember if we have to. I don't think we're required to. It is a accreditation standard. I'm not sure if it's in the state law. I'd have to check that.
We had that discussion with Senator Betancourt, and I have legislation dealing with. We have right now reporting requirement on public schools on sexual misconduct by teachers. And we have legislation that is trying to see if we can align that with our private schools, since the voucher bill, or what we all call it, it probably passed. While
There is a reporting requirement.
Please, let me finish.
Okay, sorry.
While this is a very good step, I don't think present law requires for private schools to have that type of reporting requirement.
It is required to report within 7 days of firing or allowing an employee to resign. You do have to report to the State Board of Educator certification, so that is a requirement.
I would appreciate a citation or give me some information on that.
Absolutely, yeah. Yeah, and I have reached out to your office about some of those concerns. We're trying to close that loophole and make sure that we are meeting the standards that we should.
Okay, thank you for your testimony. Thank you, Mr. Chairman.
Thank you, members. Any more questions? Senator?
No, it just, yeah, but the overall point, I'm glad the two of y'all will visit, is that the more that we find agencies that don't have this authority and that we continue to plug these holes. We've been on this mission of stopping passing the trash for 8 years. So we just keep trying to plug every hole that comes up. And there was some unfortunate publicity on one case that was spectacularly horrible. But that's just what happens to get everyone's attention of how to, continue to plug these holes. So I appreciate your testimony, and thank you all for your leadership.
Thank you. Thank you all for your testimony. So with that, I see no one else signed up to speak publicly. So is anyone present who wishes to speak on, for, or against Senate Bill 1437? If not, public testimony is closed. All prepared to vote? Chair moves Senate Bill 1437 be reported favorably to the full Senate with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa.
Aye.
Senator Huffman. Aye. Senator Miles. Aye. Senator King. Aye. Senator Hagenbu. 5 ayes, no nays.
There be 5 ayes and 0 nays. Senate Bill 1437 will be reported to the full Senate with the favorable recommendations. Senator Bedcourt. Senator King recommends that Senate Bill 1437 be recommended for the local and uncontested calendar. Is there any objection? Hearing none, so ordered.
Thank you, Mr. Chairman. It's always great to be a retread alumni and to come back to the Criminal Justice Committee. Okay, doing good work this session especially.
Thank you. We're going to go to Senator Huffman.
Yes. As an Aggie, you have to recognize the up end.
Okay, good. Yeah. Okay. Okay.
Chair lays out Senate Bill 664. Chair sends up committee substitute for Senate Bill 664. Is there any objection to adopting the committee substitute for Senate Bill 664? Hearing none, so ordered. I recognize Senator Huffman to explain the bill and the committee substitute.
Thank you, Mr. Chairman and members. Members, a magistrate in Texas is a judicial officer who presides over certain criminal cases and some civil actions, but is primarily tasked with setting bail in most counties. Under Chapter 54 of the Government Code, 25 different counties have their own qualification standards, hiring and firing processes, jurisdictional powers, and other governing statutes for their local magistrates. In order to create uniformity for these unelected officials, Senate Bill 664 adds statewide qualifications for magistrates, including being a resident of the state and county in which he or she is appointed, being licensed to practice law in the state and in good standing with the State Bar of Texas, to have not been defeated for re-election to a judicial office, and to have not been removed from office or resigned in lieu of removal from office. The bill reiterates that magistrates must remain up to date on required training regarding bail. The bill clarifies Chapter 54 magistrates' eligibility for certain removal provisions through the State Commission on Judicial Conduct, and it directs the local administrative judge to have oversight over the magistrate. It's important to note this bill is enacting statewide standards but does not prevent counties from implementing additional provisions. Because magistrates make decisions that potentially have an impact on public safety, the state must ensure that they are qualified, remain up to date on training, and have appropriate oversight to address any violations of law. Members of the committee substitute simply clarifies that a magistrate may not have been defeated to a judicial office in the election immediately preceding their appointment. It additionally introduces a similar requirement in Chapter 54A mandating that associate judges have at least 5 years of licensed legal practice. That's it.
Senator Hinojosa?
Thank you, Mr. Chairman. I guess one of the issues come up before is about judges who run for re-election and get defeated, and then
Yeah.
right away they get them. We addressed this issue.
Right. Though you couldn't have just lost your election. Yeah.
And in those situations, for example, I've seen where in some counties, Hidalgo County, for example, they have specialized criminal courts dockets
Yes.
where they appoint a magistrate.
Right.
And usually that's a judge that is retired, not defeated, but just retired.
Right.
Would this bill have an impact on them?
Are you asking about, I want to make sure I understand the question. Are you asking about like visiting judges? For example, in some of the larger counties, when a judge, like they have a capital case, they may get a judge to try their capital case for them.
Correct.
And they preside over their regular docket, or vice versa. And the administrative judge of that, the presiding judge of that regional administrative district will appoint the judge under that circumstance. So is your question, can those be elected, defeated judges? Is that your question?
Well, that's one of the questions.
Yeah, I'm trying to.
I guess the real.
You know what? It's actually a good question that I don't want to answer it incorrectly. So give me a minute to look at it because I don't know. I don't think they're officially called magistrates, and they're not associate judges either. They're a visiting judge. So that's a good question. Let me check.
The practice that I've seen, just for information, is that they will create this specialized courts. They just do nothing but run criminal cases.
Yes, I've seen it.
And then they appoint a retired judge.
Yes.
To be the presiding judge.
Yeah. And the retired, no objection. I mean, I think that's fine. I think doing the retired judge, I guess the question goes to defeated judges.
Correct.
But I think it's just I'm just not sure the visiting judge would apply to this.
Thank you.
Are you okay with voting it out, and I'll try to get those answers for you before I don't think it makes that much of a difference, but I will get the answer for you. Okay, good. Thank you.
Thank you. Any questions, more questions, members? So if not, we'll open for invited testimony. There is no one scheduled for invited testimony on Senate Bill 664. So invited testimony is closed. Chair now opens the floor for public testimony. There is no one signed up for public testimony on Senate Bill 664. Is there anyone here wishes to testify on, for, or against Senate Bill 664? If not, public testimony is closed. So the chair moves a committee substitute for Senate Bill 664 do not pass, but that the committee substitute for Senate Bill 664 be reported favorably to the full Senate with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman,
Aye.
Senator Miles, Senator King,
Aye.
Senator Hagenbu. 5 ayes, no nays.
There be 5 ayes, 0 nays. For committee substitute for Senate 664 will be reported to the full Senate with the favorable recommendation. Senator Huffman, you wish to go local, or you want to go to the floor?
No, I'll take it to the floor so I can answer that question in case there's any discrepancy there.
And we will send the Senate bills, as committee substitute for Senate Bill 664 to the floor. So with that, I need to pass them. You want to?
Yeah.
Hear my bill?
Yeah, sure. Yes. Okay, what number is that?
Here you go.
1809. Okay. Chair lays out Senate Bill 1809 and recognizes Senator Flores to explain his legislation.
Thank you, Mr. Chairman, members. So gift card fraud has been on the rise, with criminals exploiting various methods to illegally obtain or use gift cards. So this includes stealing gift card numbers, tampering with the physical cards, and using stolen credit card information to purchase gift cards. Such activities not only result in financial losses for the consumers and businesses, but undermine consumer confidence in using gift cards as a secure method of payment. The bill seeks to address these issues by creating specific offenses and penalties, thereby providing law enforcement with the tools needed to prosecute offenders effectively. Gift cards are often targeted by fraudsters due to their monetary value and the ease by which they can be transferred and used. By establishing clear legal definitions and penalties for fraudulent actions involving gift cards, the bill aims to protect consumers, the card issuers, and the merchants from financial losses and to uphold the integrity of the gift card market. So we do have a committee substitute.
Senator Flores sends up the committee substitute to Senate Bill 1809. Is there any objection to its adoption? Hearing none, it is adopted. Recognized on the committee substitute.
Thank you, Madam Chair. The committee substitute represents language negotiated with the Financial Crimes Intelligence Center and other stakeholders and does the following. It broadens the applicability to include tampering with gift card packaging. It adds two definitions to the following terms: counterfeit gift card and digital imprint. It further defines the offense to include possession and transportation of stolen gift cards, gift card redemption information, or counterfeit gift cards, possession of the unlawfully obtained data stored on the digital imprint of the gift card, and the transport of an unactivated gift card or gift card redemption information into the retail location with the intent to display it for sale. So it adds a rebutable presumption related to the possession of 3 or more gift cards and related items. Changes the penalty structure from a value-based penalty based on the monetary value of the gift card stolen to the punishment being linked to the number of items the actor unlawfully possesses. The base penalty is a state jail felony for the possession of less than 5 items involved, a third-degree felony for 5 to 10 cards, a second-degree felony for 10 to 50 cards, and a first degree for over 50 cards. It adds prosecutorial discretion for the offense, and are we going to answer any questions? And we do have some witnesses.
Okay, are there any invited testimony? Y'all can just read the name of it.
John McCord and Jennifer Tharp.
John McCord and Jennifer Tharp, you come forward as invited testimony. And Mr. McCord, you can begin.
Thank you, Chairman Flores and members and Chairwoman Huffman. Appreciate the opportunity to visit today about gift card fraud in Texas. My name is John McCord. I am the Executive Director of the Texas Retailers Association here in Texas. In Texas, the retail industry employs about 3 million people, and in addition to being a fairly significant revenue generator for the state, we are also responsible for more than $90 billion in direct income, individual income across Texas. As you know, and as I've said up here and talked about before, one of the most significant challenges that we face in the retail industry is organized retail crime. Rather than rehash the rise in ORC, I'll take my time focusing specifically on what brings us here today and SB 1809. As you can imagine, criminal enterprises are continuously evolving, and one of the methods we have seen on the rise throughout the U.S. is gift card fraud. What we're seeing now is a sophisticated approach to defrauding everyday Texans. These criminal organizations are sending 1 or 2 people into stores to take dozens, if not hundreds, of gift cards off the shelves. Then, after oftentimes stealing gift cards from multiple locations, they take the cards to a central location where the gift card redemption data is taken from each individual card and loaded into a database. After the information is taken from all of the stolen cards, these cards will then be meticulously returned to the shelves in the specific stores that they were originally stolen from. These crime rings then wait 1 to 2 weeks for the card to be purchased and loaded with funds. After that time has lapsed, they simply drain the funds from the cards and move on to the next set. These are sophisticated operations with multiple actors working in concert to defraud unsuspecting consumers. The committee sub to SB 1809 is a piece of the larger fight against ORC in Texas this session. We appreciate Chairman Flores for spearheading the effort in the Senate, and I'm happy to answer any questions about the bill or the process.
Do we have any questions? Okay, Ms. Tharp?
Good morning. My name is Jennifer Tharp. I'm the Criminal District Attorney for Comal County. Thank you, Chairman Flores, for filing what I would submit to you, this very needed piece of legislation. So Texas is at the cutting edge, joining a very small number of other states of trying to proactively go after gift card fraud. I was doing some research last night and this morning. I believe Maryland was the first to pass some legislation to try to combat this.
but their legislation doesn't actually go into effect till June 1 of this coming year. Also joining the list of states trying to combat gift card fraud include Nebraska, California, Kentucky, handful of other states, but Texas is right there at the forefront of this fraud. As already testified by Mr. McCord, some very necessary definitions are being added to the penal code. And so when you look at the committee sub for 1809, those are definitions that do not exist and are absolutely critical for both law enforcement and prosecution. It also identifies a necessary presumption that is rebuttable, as well as 4 different manner and means in which the offense can be committed. Happy to answer any questions, but I would submit to you the tracking of the language, if it looks familiar, it's mirrored off of 3251, which is fraudulent possession or use of identifying information. Thank you for your time. I'd ask for your favorable support.
Okay, any questions? All right, thank you very much. Well, I think that's all the invited witnesses, so we'll close invited testimony and open public testimony. Let's see, do we have any cards?
No card.
Okay, is there anyone wishing to testify on the committee substitute to Senate Bill 1809? All right, we'll close public testimony. Senator Flores, you ready to move your bill?
Yes.
All right, Senator Flores moves that the committee substitute to Senate Bill 1809 be reported favorably to the full Senate with recommendation to do pass and be printed. Clerk, call the roll.
Call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa.
Aye.
Senator Huffman.
Aye.
Senator Miles.
Aye.
Senator King.
Aye.
Senator Hagenbu. 5 ayes, no nays.
5 ayes, no ayes, 5 ayes, no nays, easy for me to say. The committee substitute to Senate Bill 1809 will be reported favorably to the full Senate. Would you like to send that to local? Senator Flores moves it be sent and certified for the local and uncontested calendar. No objection, so ordered. Thank you. That's it. I think that's everything, isn't it? Oh, yeah, it's pending business. You may not have enough votes. Yeah. You have to have, yeah, on that. I double checked with Karina on that P and V. I thought I was right. You can't have 3 ayes and 2 P and Vs and pass it. I was right. Good. Glad I stuck around.
Yes, thank you.
So Senator King moves to reconsider the vote by which the first committee substitute for Senate Bill 1637 was adopted at the previous hearing. Is there objection? Hearing none, so ordered. Senator King moves to withdraw from consideration the previous committee substitute. Is there objection? Hearing none, so ordered. Members, Senator King sends up a new committee substitute for Senate Bill 1637 and is recognized to explain the difference.
Oh, thank you, Mr. Chairman, and thank you for taking this up on kind of short notice. This was the deadly conduct bill we discussed last week, and there was some really good testimony. As you recall, there was a presumption that is in the statute that if an officer even pointed their gun in the line of duty in a very appropriate way, in alignment with their training and expectations, that there was a presumption that they had committed the offense of deadly conduct. The bill as presented had some issues. Good suggestions came up, and so what this committee substitute does is simply removes that presumption as to a police officer. And it also clarifies that the offense of discharging a firearm at one or more individuals does not apply to peace officers in the actual discharge of their official duties. In other words, that the deadly conduct statute does not apply in those circumstances. And the most critical piece here is that the presumption is removed. There's no presumption if an officer acting appropriately points their firearm at someone that that they are committing the offense of deadly conduct.
Mr. Chairman.
Senator Hinojosa?
And I guess the presumption we're addressing also applies to subsection F, where the police officer actually discharges the gun or the weapon?
Yes, there's no presumption that is the act of deadly conduct. Now, obviously, they can be, if it was inappropriate use of their firearm, and they can be prosecuted under other offenses, and they can be prosecuted under deadly conduct as well. It's just that the presumption is removed.
Okay.
Yes, sir. I'm sorry if I wasn't clear on that.
I'm good.
Very good. Members, any more questions? Member Senator King moves the adoption of the committee substitute for Senate Bill 1637. Is there objection to the adoption of the committee substitute? Hearing none, the new committee substitute is adopted. Senator King moves that committee substitute for Senate Bill Senator King moves that Senate Bill 1637 do not pass, but that the committee substitute adopted in lieu do pass and be printed. The clerk will call the roll.
Chair Flores?
Aye.
Vice Chair Parker? Senator Hinojosa?
Aye.
Senator Huffman?
Aye.
Senator Miles?
Aye.
Senator King?
Aye.
Senator Hagenbu? 5 ayes, no nays.
Be 5 ayes and 0 nays. The committee substitute that is reported favorably to the full Senate. The committee substitute for Senate Bill 1637. Would you like to go to the floor with this?
Y'all okay with that, you think?
I'm okay with
I
it.
think so.
You want to go to the floor? Or committee, or would you like it to refer to local and
I
uncontested?
think you can go to local and uncontested.
So Senator Huffman recommends is that committee substitute Senate Bill 1637 be recommended for local and uncontested. Is there any objection? Hearing none. So ordered.
Mr. Chairman.
Mr. Senator Hinojosa.
Thank you. But I just want to thank Senator King for working with the committee members and trying to address some of the issues and concerns that were expressed not only by us, but some of the testimony that we heard from all the stakeholders that were involved in this, dealing with this issue. So thank you.
Well, and thank you. This was a really good solution and a much more elegant one than was proposed in the original bill.
And thank you, members. And as chairman, I wish to I take great pride in being able to work with fellow members who work together to establish good public policy and to continue to work together to make our Texas a safer place and a place where some of the best applications of criminal justice in the country. So with that, members, is there any other business to come for the committee at this time? So hearing none, Senator Huffman moves that the committee stand in recess subject to the call of the chair. Thank you, members.